Welcome to Cooperative Network's Fall Update webinar. I am Daniel Smith, President and CEO of Cooperative Network. Thank you for joining us today. It is our honor to have with us today attorneys from Fredrikson Byron, who will discuss important matters in corporate governance, including cooperative annual meetings, governance best practices, and tips for managing delinquent accounts. Fredrikson Byron was founded in Minneapolis in 1948 and has since grown into an international firm of over 300 attorneys in more than 50 practice areas, who serve a wide variety of clients. Cooperative Network is proud to have Fredrikson Byron as an associate member. Later on, Cooperative Network State Directors of Government Affairs, David Larson and Jennifer Wickman, will provide updates on current legislative issues in Minnesota and Wisconsin. We have a lot to cover this morning, so I will turn it over to Dan Mott. Mr. Mott is a shareholder in Fredrikson Byron's Corporate and Securities Group and leads the firm's Cooperative and Agribusiness Group. Welcome to you, Dan, and to the rest of your team. Thank you for joining us today.
All right, thanks, Dan. Appreciate the opportunity to be with you all today. We probably would prefer to do this in person, but that isn't the world we live in right now. And this is also a much more convenient way for all of you to participate in this. And so we're looking forward to the opportunity this morning. As Dan indicated, Fredrikson is a large regional firm. We have over 300 lawyers, and the largest majority of which are in our Minneapolis office, but we have offices in Mankato, Fargo, Bismarck, and a number of other places as well. We have a significant agribusiness and co-op practice. I've been doing this for longer than I should probably admit. I used to tell people how many years, but I decided that aged me, so I better quit saying how many years. But I've been doing it for a long time. Working with co-ops in a variety of different types of projects, everything from governance to transactional practices. The rest of the team that's joining today is going to really lead the substance of this presentation. Levi and Sarah are going to talk about issues related to governance, your annual meetings, and potentially what we've referred to as kind of a legal governance checkup or review of your articles and bylaws. There isn't a right answer to this, but what we're hoping to do today on the governance issues is give you some nuggets that might be useful and some food for thought about things that you ought to give some thought to in your governance documents before they become issues rather than after they become issues. And then Steve Kinsella, who is part of our bankruptcy group, is going to spend some time talking about how to deal with financial distressed patrons and how you protect the co-op's interests when you're dealing with some of these financial issues. We've had a number of these concerns that have come up over the past several years. And what I usually find is that co-ops tend to address these issues after it becomes a problem and you've got a significant delinquent account or bankruptcy on your hands, rather than addressing it in advance. So Steve's going to talk about some things that you might be able to do to better protect yourself from financial distressed patrons. We will be taking some questions and answers at the end of this. I would encourage you to use the chat function, and we'll kind of try to keep track of the questions that come in. And when we get to the end, we'll also give you an opportunity to pose some questions. But if you don't get your question answered, you don't want to ask the question today, or you just want to follow up, the information on the prior slide that Levi provided has our contact information, and we'll send out some information to the participants here afterwards so that you know how to get a hold of us, just in case there's some question that comes up afterwards. So with that, I'm going to turn it back over to Levi, who's running the slides and kind of leading the rest of this presentation. And again, I encourage you to ask any questions that you might have in the chat feature or at the end of the presentations. So with that, Levi, take it away.
All right. Thanks so much, Dan, and thanks to Cooperative Network for having us here today. I'm going to actually turn it back over to Sarah to kick us off on the first couple of slides.
Sure. So my name is Sarah Tucher. I'm happy to be here. So this slide, you'll see it says step 1, get organized. I have 3 little kids at home, and you know, we always repeat a lot of silly like mantras to try and get them motivated. This has become a mantra that I've actually adopted. It's just helpful to keep in mind, and it's gotten to the point now in my house where if somebody says step 1, you hear 3 little voices saying, get organized. So I thought I'd include it on this slide. So here, Levi, I think I'm having trouble getting it to go to the next.
Okay, I'll go to the next one.
Perfect, thank you. So first step for me of getting organized is always to gather my resources together. This is a little different given that you already are formed. Typically, in terms of the statutes, when we're looking at forming a co-op, it's, you know, of course, very important to dive into the various options at the state level. Here, you should know which statute is governing your co-op based on your articles, or you can look at the Secretary of State website to see which particular statute you were formed under. I'd recommend, you know, obviously you don't have to do a deep dive into the statute, but it is worth taking a look and seeing if anything has been changed. We are seeing some updates to statutes based on a lot of the technological improvements. So for example, the Zoom technology, we're seeing some updates to provisions to allow for that type of technology to be used. Of course, also dust off those governing documents, get out articles, bylaws, and then you should take a look at policies that you might have. The tricky thing with this is that it might be formal or might be informal. So it might be worthwhile to speak with somebody who has helped out with organizing your annual meeting over several years if you're new to the organization. And then if you don't already have the annual meeting procedures written down, perhaps as you get ready for your annual meeting, consider writing them so that somebody else would be able to take over the reins or at least know what the process was. And then finally, contact your legal resources and accounting resources. You may be required to present an audited financial statement at your annual meeting. Sometimes they can be unaudited. It depends on what's in your bylaws. And so it's important to, of course, contact those resources to understand what you have and what you need. All right, I'm also a checklist person. So for me, the first step is, you know, getting together your timeline. And this is largely driven by state law as well. And it should be contained within your org docs. So figuring out within your bylaws, typically what your notice period is and how you're setting your record date. That may be in your bylaws or it might just be in the statute as well. And then determining your meeting date. And in terms of giving your notice, you will need to include the time, the place, kind of a general overview of the purpose. So if you're having director elections, for instance, you'll need to include information there. It's been interesting over this past year, of course, the location question within your notice has been a little bit up in the air. So last year, of course, things were very tightly buckled down under the COVID pandemic. This year, it might be a little different for you. It might look different for your co-op. So you should consider how you're going to hold your meeting and your vote. So we know that co-ops typically struggle to hit their quorum and to get member participation. And so you might want to consider how you're going to hold your meeting and how that can affect your quorum and hitting that number. Over the last year, several co-ops took advantage of executive orders in order to be able to hold virtual meetings. And in many cases, it was wonderful. We had a few clients who had the largest participation they've ever had. You should think about that and whether having virtual meetings and increasing your participation is, you know, a goal of yours, or whether you have the belief, your board has the belief that, you know, members should be committed to coming to a physical place to participate, especially when it comes to elections. So maybe give some thought to that. But when it comes to holding your annual meetings this year, you will have to pay careful attention to what's actually in your bylaws, because many of the executive orders that were used last year in order to hold those virtual meetings or in order to hold director elections or other voting issues electronically or by mail have expired. And so if you did not change your bylaws over the last year, you will have to follow the process that's written. And to be clear, most state laws require a specific permission to be given in order to hold elections of directors by mail vote. So that should be specified within your bylaws. And if it's not, then you will have to hold an in-person meeting. And so that's something just to keep in mind. If you will be holding a virtual meeting, think about the voting mechanism that you will use. Most people think, well, if I'm holding a meeting via Zoom, I should be able to have, sort of a show of hands or use a survey function. However, under most statutes, it says that you can use electronic ballots only if you're able to actually authenticate the member that it was just the members that placed the vote. So if you're holding a Zoom meeting that's open to public participation, it's not possible for you to use an electronic voting method, or we wouldn't at least recommend it, because you won't be able to tell if it was a member that voted or if it were a different member of the public. We've seen clients who've used closed meetings, so they only provide a link to the meeting to members, and in that case can authenticate that only members were able to vote. And so that might be a way that you can conduct the vote, but more commonly, we've seen clients holding virtual meetings, but using a mail-in ballot. And you should think about the timing of your mail-in ballot as well. You can have it where, you require all the mail-in ballots to come, the day before the meeting. And so the meeting is essentially reporting the tally of the votes. Sometimes co-ops will have it where it's more of a live count or a live election process for the nominations for directors, which I'll let Levi get into. But these are all things that you should think about as you prepare for your annual meeting.
Thanks, Sarah. I'm going to talk a little bit about business that you should take care of at the annual meeting and how to prepare for that as you're leading up to your annual meeting and going through the timeline and the checklist that Sarah discussed. Obviously, one important consideration and one important piece of business at an annual meeting is the election of the board of directors or open board of directors seats. And one thing that you need to think about probably in advance of your annual meeting and during your timing, during your planning process, is what is the process for identifying qualified candidates to run for those open board seats. And here, we'll talk a little bit later about different options that you might have, such as having a nominations committee or some other method for obtaining candidates who meet whatever criteria your cooperative might have for board service. But here, what we're really talking about is what are the requirements under the statute, under your organizational documents, and under any board policies that you might have. It'll be really important to look at those and make sure that the process you are following for nominating directors aligns with what's in your organizational documents and what's in your various policies. That may not be what you ultimately want to do on a going forward basis. And we'll talk a little bit later, as I mentioned, about what changes you could make. But it's important when you're preparing for your annual meeting to be consistent with those documents for sort of sourcing director candidates. One thing to think about after you've determined what your process is what other requirements do you have to sort of check the box on? Do you need to fill certain industry roles? Do you need certain geographic representation for your directors? Are there outside directors who could potentially serve on the board? And just making sure that you have identified a sufficient number of people, at least one, to fill those roles so that you don't end up with open board seats and no one to be elected at your annual meeting. So as I mentioned, we'll talk a little bit more in the presentation to come about a nomination committee, but a lot of cooperatives do assign sort of the nomination process to a subset of the board, a committee, and delegate them certain authority and certain tasks to sort of go out and survey the members and identify, qualified candidates who can bring skills and experience and diversity of opinion to the boardroom, which, as we'll talk about in a little bit, is all helpful. The other item I just wanted to mention was, you need to think about in your planning process, what other business do you need to accomplish at your annual meeting? As Sarah mentioned, you may have requirements to present financial statements, and you have those financial statements ready to go. If it's an audit, will the audit be completed by the time your annual meeting rolls around? Kind of all those different considerations to make sure that you are prepared to do what you need to do at your annual meeting. The final item we just wanted to mention is, do you allow your members to make resolutions at your annual meeting? And as part of that, I think you need to ask yourself, what if a member does make a resolution at an annual meeting and that resolution gets passed? Is that effective? One example that we've thought about before is, what if the members make a resolution to fire the CEO and that passes? And perhaps the board likes the CEO and doesn't want to fire that person. Is that resolution passed by the members effective, or does that create some ambiguity and some question about, in that example, who is actually running the organization? So one thing to consider, would be to have something in your organizational documents that would address that situation. You might have a policy or an item in your bylaws that says that resolutions brought at an annual meeting by the members are advisory only. The board will take them under consideration for adoption or an official vote to the members. Or you may have resolutions presented outside of the official annual meeting. So if a member wants to submit a resolution, it's outside of the official annual meeting. It's maybe happening on the same date, but it's not during the time period that the meeting is actually going on, and therefore is not sort of part of the official annual meeting, and therefore would not be effective. So these are more questions to ask in sort of scenarios to think about. We find that it's always better to think about these in advance. That's sort of our job to think about these maybe remote eventualities, but things that could have a significant impact and disruption on the cooperative. So, to sort of summarize this portion of the slideshow, really just focused on getting ready for your annual meeting, getting your ducks in a row, sourcing all of your various pieces of information, the statute, the organizational documents, and then really having a good plan for how you run your annual meeting, how you do your vote, how you do your elections, in particular in light of COVID and sort of continuing uncertainty around in-person meetings and maybe a preference for not having an in-person meeting. And then again, dealing with other items of business that might come before the annual meeting. So things to consider as you're perhaps planning for this year, or if you're already down that stage, to keep in mind for next year. We are going to transition now to what Dan mentioned. Dan mentioned is sort of a legal checkup of your governing documents. And what we view this as is it's a legal review of your articles, your bylaws, perhaps your membership agreements, and your board policies, where we or your legal advisor takes a look at all of those documents, has a chat with the board and management, consults the statute that you're incorporated under, and make sure that, one, those documents are in compliance with law, and two, making sure that those documents and those policies actually reflect the way the cooperative is operating and the way you intend to operate, and provides any flexibility you might need in the future for future changes or future advances. It's a good idea to do this from time to time, even if there's not anything pressing. Sarah and I were joking, we've looked at, in probably the past year, at least one cooperative that was incorporated in 1905 and hadn't updated their articles since then. And you can just imagine, of course, all the changes that have happened in that time period. Needless to say, their documents were a bit outdated and needed some updates. So again, a good idea to periodically review these items just to keep things fresh and, hopefully not let it go, 116 years in between your reviews. Just a little bit more specificity on the value of the legal review. From our perspective, as Sarah mentioned, you need to understand the statute that you're incorporated under, and there are various requirements. Thou shall do XYZ, thou must have XYZ in their articles and bylaws. So we look at all that and make sure that your organizational documents actually do comply with those statutory requirements. The other thing I mentioned is just making sure that your legal requirements, your legal documents actually match the operations and intent of your cooperative. We often talk with management and board members and we say, well, your bylaws say XYZ, and they say, well, we don't do that. We've never done that, and we would never do that. So making sure that there is actually consistency between the operations and the legal requirements is always a good idea. As you all know, there are certain very particular tax requirements applicable to most cooperatives, and having your organizational documents align with those tax requirements really helps ensure, one, that the co-op gets the tax treatment that it is desiring, that the members get the tax treatment, and that there aren't any questions from the Internal Revenue Service if there was to be an audit or some sort of review. And then lastly, just another value is just to facilitate strategic options for the co-op. Modernizing your governance structure. You may have 21 board members, which may have maybe made sense at some point in time, but you find that that's just unworkable now, so you want to reduce the board to a more compact group. Thinking about your financing structure, what sort of plans do you have for either debt or equity financing, and what is the flexibility you have under your organizational documents to do that? And finally, business combinations. We work on and see a lot of combinations between cooperatives and other entities, and oftentimes that involves a very detailed review of organizational documents. And we're looking for items that either prohibit that type of combination or provide a roadblock for some approval, or otherwise reduce the flexibility that the cooperative might want to have to engage in that type of transaction. And then, so those are the benefits. Moving on a little bit to the risks of legal inconsistencies, things that we would seek to identify in advance and rectify before they became a problem. But there could be liability to the cooperative. If the statute says that the co-op can't do something, but the co-op does it because there's an inconsistency with the organizational documents, that could result in legal liability to the cooperative. Also for directors and officers. Directors and officers have a fiduciary duty to the co-op to act in the co-op's best interest. And a lot of that is making sure that actions taken by the directors and officers on behalf of the co-op comply with the organizational documents. So again, understanding what those requirements are and providing the flexibility that the co-op might need to not risk sort of that inconsistency. As we talked about, and we'll talk a little bit more later in the presentation, there's some fairly serious tax consequences if the tax and patronage provisions in the bylaws are not consistent with the requirements under the tax laws. And we'll talk about that a little bit more in a bit. And then just two other items is you could find yourself in an environment where, perhaps some officer signed a contract and the officer didn't have the authority to sign that on behalf of the co-op. Now there's a question about whether that contract is enforceable or if it's invalid. And similarly, there are a lot of covenants and loan documents that relate to compliance with laws, compliance with contracts, and making sure that you don't run afoul of those, which could have some obviously serious consequences for the operation of your co-op. I am now going to pass it over to Sarah to talk about the next item.
Yeah, so at the heart of co-op operations, obviously membership issues. So as you're reviewing your governing documents, typically the membership provisions are set out in the bylaws. Some statutes require discussion of membership in the articles, but typically you'll see it in the bylaws because you want to have a little bit more flexibility with how those membership eligibility criteria are described. The most important thing with your eligibility for membership is to really be clear about exactly what the criteria are. If you're giving board discretion to accept candidates for membership, you need to be consistent across those candidates. Membership, especially in an agricultural cooperative, can have some fairly serious antitrust components to it. So you'll see the bullet point toward the bottom of the slide talking about Capper-Volstead compliance. You probably are aware, but the Capper-Volstead requirement is that members must be producers, and that means that they're producers of farm products with some risk involved in that enterprise. And so your criteria for membership can include, of course, being a producer if you're an agricultural cooperative and you want to seek that protection under Cooperative from antitrust lawsuits. Also, your eligibility will probably include the candidate agreeing that they would be subject to your bylaws and your articles. And then also we commonly see some sort of membership agreement. So they have to sign that membership agreement and be bound by it before they can become a member. And the membership agreement will typically include provisions for termination of the membership, which should be consistent with these bylaws. But it'll also include common contract components like indemnification. So if they do something that causes liability for the cooperative, you would have a right to seek indemnification from them. There may also be delivery components involved in the membership agreement. And so you should carefully review that against your bylaws as well. The procedure for expulsion or termination of membership should be really clear within your bylaws. We want to have an automatic termination of voting rights, especially if there's a Capper-Volstead component involved. So the moment that they don't follow whatever the eligibility are, don't meet those criteria, they're automatically terminated and cannot continue to vote. You also want to discuss the disposition of allocated equity and the fact that it would be rotated consistent with other members. So they don't have an automatic right once they're terminated to demand all of their equity. Are there due process procedures? Some state laws do require some sort of a hearing, or the member can go before the board and try to argue for reinstatement or for continuing membership. So you have to be really clear if you're going to allow that, or if you have to allow it under state law. Finally, with respect to the Capper-Volstead issues, you want to make sure that you're periodically purging your membership list. So you want to be sure that you're doing some sort of process, and this doesn't have to be spelled out within the bylaws, but just as a governance note, some sort of survey or other process to check through and make sure that your members still do meet the eligibility criteria. The risk of this, of course, under Capper-Volstead, if you have a member that is no longer a producer, you can lose that protection against the antitrust suits. And so you want to make sure that you're going through and asking and making sure that they're still producers, or that they are still following all the contract requirements that you've laid out in your membership agreement. One suggestion that we recently heard from a client was making sure that they have any field reps that are involved in going out and servicing the members. Have them report back anything that they learn about the member that could be impacting the eligibility for membership. So just making sure that your communication lines are clear when it comes to those different criteria. All right. I think this is you, Levi.
Yep, sorry, I was just unmuting myself. So I'm going to talk a little bit about equity issues. It'll be a little bit of a common refrain here, because I'm going to say, in order to determine what equity is authorized to be issued to your members, you need to consult the applicable state law and also look at your articles and bylaws, because that'll sort of frame the issue and frame what you're able to actually issue to your members. So here we're talking about what types of equity is the cooperative authorized to issue to its members. And we typically see these in kind of three broad categories. The first being membership equity. This might be the one common share to each member that is affiliated with voting rights, that allows them to vote at the annual meeting for directors and on other issues. So that's kind of the membership equity. The second piece would be the patronage equity. This might be the cooperative's way of allocating patronage payments and keeping track of that within the cooperative. And then the final piece would be investment equity. This is sort of, does the cooperative have the ability to issue preferred stock or other classes of stock for a particular purpose? maybe that's to raise capital for a particular project, or some sort of combination consideration, or things along those lines. So again, important to understand what these different categories are, what your cooperative's intentions are with respect to them. And then one thing we often see when we review articles and bylaws is that there will be classes of authorized equity that aren't ever used, or they're not used for the purposes that are set forth in the articles and bylaws, which again creates that legal inconsistency and some ambiguity about what rights a member or a shareholder may have with respect to a particular class of equity. And then as part of that review conversation, we asked, what flexibility might you want to have in the future? And we try to build in that flexibility in the articles and bylaws to provide the board, if that's what's desired, with the ability to issue different classes of equity to facilitate some of those more strategic types of investments. Just a note on the investment equity, there usually is sort of an additional overlay on that. There's some statutory authority, depending on what state you're in, about the amount and sort of the characteristics of that equity that can be issued. Oftentimes, if we're talking about preferred stock, that would maybe have a preferential return, almost like an interest rate return on that stock. There are often limits on the amount of that return, sort of a dividend limit on the amount that can be paid on that preferred stock. And that is usually a matter of applicable law. Oftentimes, these preferred equity interests will have a dissolution preference. So if the cooperative is dissolved, preferred equity would get preferential treatment, hence the preferred bit in a dissolution over common stock. So all of those different characteristics are important to understand, and important to know that you have the authority in your articles and bylaws and under the applicable laws to issue those. One other consideration that we think about when we're sitting here with our lawyer hats on are there any security laws considerations that we need to think about? Is the cooperative making some sort of public offering, or not necessarily a public offering, but making an offering of equity that is subject to various federal and state security laws? Are there registration requirements? Are there exemptions to registration? All those sort of items, your qualified legal professionals can help you work through, but things you need to think about because they could result in some liability to the cooperative. Another equity issue that I just wanted to mention quickly is you should have in your articles or bylaws a first lien on equity issued to members. So this means that the cooperative, if the member owes money to the cooperative would have a lien on those equity interests and could foreclose or set off against that lien to recoup from the member, sort of as a secured creditor or as an equity holder. If there are specific questions on this, I'm going to put Steve on the spot at the end of the conversation, because it's a sort of a complicated interplay between state law, Uniform Commercial Code, and bankruptcy to understand kind of the rights and obligations of the co-op in this lien environment. One thing we do like to see in the bylaws is that there's a right to offset against amounts owed to the member, but not the obligation, so that there's the ability for the cooperative to do that. They're not obligated to. And then we also like to make sure that that's not reciprocal. We don't want the member to have an offset right against the cooperative. So again, an item that we focus on when we're doing our article and bylaws reviews, and make sure that works for the cooperative, and people understand what enforcement rights might go along with that. We're going to pass it over to Sarah.
All right, so the next section we're going to talk about are the directors. And here again, state law is going to factor in. Typically within the state law, they'll have requirements for at least a minimum number of directors. So you should make sure that you're compliant with that. In terms of figuring out the number of directors, obviously, you'll have a sense of what's working for your cooperative or not. We do typically recommend an odd number of directors just to prevent any stalemate. But you should think about other specific director qualifications that would be important to improve the functionality, the efficacy of your board. And just a side note too here, when we're looking through and doing the governance checkup of the governing documents, this is typically an area where I find gender specific pronouns. And obviously that's not a huge reason to completely overhaul your governing documents, but if you are doing a cleanup, it's nice to update those gender specific references to be a little bit more inclusive, as we are seeing more women involved in ag and hopefully more women directors on your board. So here, when you're thinking about your director qualifications, think about, again, consistency between your documents and your practices. Do you have districts? Will you require, certain representation from different districts? Do you have age limits? We've seen the age limits increasing, and I think that that's just a natural part of, our population is getting older and works longer. But you should think about that and what effect it might have on getting younger folks involved too. Think about term limits and what importance that might have. I think one thing, a side note also to think about with this pandemic, last year, a lot of co-ops deferred their elections. So this year, you might want to be intentional about, if you have a staggered board, how your elections will work and what candidates are up in terms of keeping some of your institutional knowledge. A lot of times we see that cooperatives use staggered terms so that like 1/3 of their directors are up for election in each year. And if you deferred last year, you're potentially looking at 2/3 of your directors turning over this year. So that's something to just consider and keep in mind. When we talk about relevant experience, you'll see on my next slide, but a lot of times I think there's very little control over, especially in an agricultural cooperative, what type of experience you're getting. But hopefully you'll get some directors, or you'll have a training program to help with some, financial knowledge, legal knowledge, knowledge of what their fiduciary duties are in your onboarding process. But if you do require certain relevant experience, you should state that in your bylaws. One example that we've seen recently, in a cooperative that maybe has different allocation pools based on different types of businesses, maybe you'll have certain seats that are aligned to one type of business. So, being an agricultural producer versus being a dairy farmer. So keep in mind too that you can describe those qualifications within your bylaws. Minimum patronage volume, I haven't specifically seen that, but that could be a consideration to make sure that your directors really have skin in the game and understand what's going on with the cooperative, and then make sure that they're not a member of a competitor cooperative, so that you don't have some duty of loyalty conflicts going on, any conflict of interest. Think about your nominations process. So we see 3 different types of nominations. It can be, as Levi mentioned, nominations from the floor as you're actually holding your annual meeting. You can also take nominations in advance by petition, or you could also have a nominations committee. And so you should think about what will work best for your cooperative and what might allow your board to have a little bit more oversight of the different candidates that are coming through, and that could be helpful to keeping the board, as a productive and efficient leader of your cooperative. And finally, think about outside directors and whether they're desired or authorized. Many statutes do allow you to have outside directors. I know that within the agricultural space, it's sort of been frowned upon, just given that they're not producers and that maybe they don't have the same background in terms of farming. However, you can structure outside director roles so that they're non-voting, and so that at least then you're getting an outside perspective, especially when it comes to financial issues. It might be helpful to have somebody that has a really deep background in that area. So think about whether that's something that could be helpful to you and how you would structure it within your bylaws. All right. The next slide, Levi, if you can advance it. Awesome. So here we get a little bit more into that nomination. So it is typical for cooperatives to have the self-nomination of director candidates. But again, governance by who shows up can be a little bit risky, which is why we have recommended, the other nominations procedures that I discussed earlier, either in advance or through a committee. If you're taking self-nomination from the floor, keep in mind that at least in Minnesota, where you have a quorum requirement that's 10% of the first 500 members, they could be elected by as few as 26 votes. And so that can be a risk to your governance. Think about how to protect against the inexperienced or counterproductive directors. Again, I think your nominations process will be key. You can also do, board of director evaluations, thinking about identifying the areas of weakness that you might have and starting to potentially groom, different members that you think might be interested. And that will just set up sort of a pipeline of good governance to come. And then we do have the note too, though, that it is the members who have the right to actually elect. So making sure that your nominations process still does allow for, finally the members to have their say in who's elected. Levi,
Thanks, Sarah.
turn it over to you.
Awesome. I'm going to talk a little bit about.
Excuse me.
I'm going to
I
talk
had a question for Sarah.
Oh, sure.
When you mentioned in your last, on the last slide there, not from a competitor co-op. Well, you see, our co-op is a large co-op, allied co-op, and on both sides we have very large co-ops. And anyway, a lot of our members and potential board members do buy from both co-ops. So how do you make anybody ineligible from a competitive co-op is what I'm getting at, because see, our qualifications to be a director is a minimum of $10,000 worth of business. Well, in a way that is not much, especially for large farms these days, where they can very easily be buying $50,000 from one co-op, $100,000 from another co-op. But how do you handle that? Not a competitor co-op is what I'm getting at. Is there I don't know how we'd handle that.
Yeah, so I've seen this, specifically the example I'm thinking of is within the dairy industry. We've seen that the dairy co-ops are pretty protective of their membership. And so they'll say, that if you're going to be a director of our organization, you can only be a member in our cooperative. You're not going to be, selling to another co-op and have, your feet in both. You sort of need to pick one. And if you want to run for director candidacy in ours, then we would expect that you would be a member of just our cooperative. Hopefully that answers your question.
Yeah, and I think we could also have a little bit of
Yes.
a discussion about it at the
I was
at
just
the end.
going
if we want
to say
to
that.
All right, perfect. Well, thank you. Levi, I think we'll switch over and get you going on the patronage distributions.
That sounds great, and thanks for the question. So I'm going to talk a little bit about just the provisions of the bylaws to ensure that the cooperative is getting the appropriate tax treatment that it desires with respect to the patronage distributions. This is one area that we spend a lot of time on with clients when we're doing our bylaw reviews. And we work really closely with the tax preparers and tax advisors to make sure that the language in the bylaws, one, accomplishes the legal requirements under subchapter T to achieve the desired tax treatment, and to make sure that the tax preparers and the accounting folks at the cooperative are all on the same page about how that's going to work and how that should work, to make sure that we don't have a risk of a challenge from the IRS or that deduction getting disallowed. So there are requirements under subchapter T, and we look to build those into the bylaws to make sure, like I said, that they match. Well, a couple of considerations here, one would be, are there minimum patronage amounts that must be distributed? Again, would we consult subchapter T in the bylaws on those items? It is essential in order to get the proper tax treatment for the cooperative that the members have consented to take patronage distributions into account for their income tax treatment. So essentially, they will pay tax on those distributions rather than the cooperative, and they've consented to that treatment. There are three ways to accomplish that. You can have a consent provision in your bylaws, and we often see that, and we often recommend that. I think the question there is, if you're paying patronage to non-members who are not subject to those bylaws or not bound by those bylaws, that provision would be ineffective with respect to those members. So then you would move on to one of the other options. There can be a written agreement where the member agrees to accomplish that tax treatment, or you can pay by qualified check, again, to act as that written agreement for that tax treatment. There is, if you're going to have it in your bylaws, you need to provide the member a copy of the bylaws and then also a description of the effect of that provision so that the member can understand what that consent means. There's a written notice provided with it. They can see the language of the bylaws, and then the notice also illustrates what the tax consequences are, just so that there's sort of the informed consent about that treatment. So this is obviously a topic that is specialized and requires a lot, like I said, input from accountants, but these are the general things to keep in mind to make sure you're kind of doing what you need to do. The other item we see and talk a lot about are equity retirement programs. What is the cooperative's plan for retiring older equity? Is there a time period for that? Is there a revolving plan or some sort of base capital plan? How do you deal with the retirement or the death of an individual member? Does that automatically trigger a redemption of that equity or retirement of that equity? Or does that stay outstanding and is payable to the estate? There's some considerations there. Also, what about when it's payable to an entity? And what if that entity changes? How are you tracking that? Those sorts of considerations. The key here, in our view, is to make sure that this program is documented, that it's clear to everyone what are the policies and procedures that are going to be followed, just so that there's no ambiguity and to some extent there's not too much discretion where there could be a potential for an issue. We always feel like it's better for everyone just to be on the same page about how this is going to work, which helps avoid some complications down the road. Just another sort of tax-related note. There's an obligation, a federal income tax obligation under subchapter T that the cooperative operates on a cooperative basis. This is a sort of a vague concept, not super well defined, but I think over the years, people have kind of gotten to understand what this means. And this essentially means that there needs to be a pre-existing legal obligation of the cooperative to make distributions, sort of patronage, earned income to be distributed to the members. Or to the patrons. And again, this leads into a little bit of a question of, are you making distributions to only members or to members and patrons, and are some of your patrons non-members, and dealing with those types of items, are considerations as well. One thing that we look closely at when we're reviewing our articles and bylaws in relation to this pre-existing legal obligation is, does the board have discretion to implement reserves, to put money into reserves? Because if there's really broad discretion for that, unlimited discretion, 100% of proceeds could be put into reserves, that seems to negate the requirement that there's a pre-existing legal obligation to distribute. So we often see, and we recommend that there's a defined limit on the percentage that can be placed into reserves just to preserve that pre-existing legal obligation. And that limit, it can be changed on an annual basis, but if it is, it should be changed prior to the year starting, so that, again, we preserve that pre-existing legal obligation. It's not sort of something that's changed midstream and argue, well, there's a lot of discretion here for the board to change that. So that's something we often look at. Just a couple of other notes, are there allocation pools? to different types of patrons, depending on what their kind of the business they're doing with their cooperative. Are those used? Are they actually authorized? And then one area that's quite important is how are losses dealt with? Are there provisions for how those should be assessed or allocated to the members? And Sarah's going to touch a little bit on some specifics on losses on the next slide.
Yeah, so I will say I'm a CPA, but I'm inactive in terms of my CPA. And so, and I also never did tax. So I do defer, of course, to what your tax accountants say. However, in terms of structuring the bylaws, I'm aware obviously of the different options here. So you want your losses, how you're going to handle your losses to be clearly defined. Your bylaws should provide some flexibility to address the losses in various ways, but you want to be, again, clear about what those options are. The treatment of losses has been a subject of numerous court cases and private letter rulings. And so you want to ensure that the state law and the bylaws allow the use of what's been, deemed to be acceptable methods of handling losses. So here I've listed just a few. So the first, to net among the patronage pools means that you're going to net the loss by the allocation unit across the income of profitable units. And this will require notification to the members. So you should be aware of that. The second option is basically a receivable. So you can satisfy a receivable with a cash payment, or you can offset allocated non-cash patronage instruments earned in the future. The third way is a carry forward, and this will reduce your patronage sourced income in the future as well. The impact is in proportion to the patronage in the future rather than in the current loss year. And so this is usually the least attractive option in terms of equitable treatment. The fourth is usually an attractive option, the offset against reserve, basically against your retained earnings. This will reduce your member liquidation preference, but it will not reduce their allocated equities. And so the co-op may be able to get a tax refund to the extent that they paid taxes on patronage sourced income that's in the reserve. And then the fifth way, the offset against allocated equities, this is usually seen as the most advantageous way to handle the loss because members can claim an ordinary loss on their income. So these are some methods to keep in mind. And again, I would encourage you to speak with your tax accountant when figuring out how to best handle a loss.
Hey, Sarah, I was just going to mention that I glanced at my clock and we're
Getting close.
Yeah, give Steve some time to do his part too. So just,
yes, for sure. So the special pass-through issues, again, this is more just a disclaimer of make sure that you have something in your bylaws to discuss how the deduction under 199 AG will work, and make sure that your bylaws provide for PERPMs. And that is more a labeling issue, right? So make sure that if you are making a payment that you intend to be a PERPM, that you have that right within your bylaws. Again, seek expert tax advice on this one. And then indemnification and insurance. Here, this is typically something that's provided by state statute. And so statutes usually provide boards and cooperatives with the right to provide indemnity to officers, directors, basically anybody that's working or would incur liability as a result of their role, carrying out functions for the cooperative. However, you'll want to carefully review if you have director and officer liability insurance. You want to understand your coverage and the exclusions and how your coverage works with your indemnity clause that's within your bylaws. Understand that the director and officer liability insurance will cover a lot of those expenses that may arise, but there may be gaps. You should also be aware that many statutes also provide for a limitation of liability clause that can be included in your articles. I've seen several sets of articles that don't include it. Perhaps it was an oversight, or perhaps it was added to the statute after the articles were initially filed, but that would be something that would also be important to include in your articles.
Thanks, Sarah. I'm just going to touch briefly on another item that we hone in on when we're looking at articles and bylaws, and that's the dissolution provisions. So a dissolution is essentially, the decision has been made to wind up the entity and to dissolve it to satisfy all liabilities, convert all assets to cash, and then anything that's left is distributed to the members. This is not a topic that people often like to talk about on the front end, because things are going great. We expect this cooperative will be around forever. It's never going to dissolve. But we've seen a number of successful cooperatives, for whatever reason, a variety of reasons, dissolve. And it's important to make sure that you have the provisions for dissolution, in particular, setting out the priorities of sort of that remaining cash after liabilities, or assets after liabilities are satisfied, making sure that those priorities are established and are correct. And again, tie back to some of the equity issues: who gets paid first, and who gets paid, second, and what's the order there. Just to note that there should be a time period for residual distributions. So if there's additional assets that need to be distributed, do those go back to former patrons, former members? And is there a time period over which those are going to be distributed? If you don't specify, we think that a 10-year look back is common. If you don't specify, it could be forever. You could have to go back, to 1905 in that cooperative example I gave before, and figure out who is entitled to certain distributions, and that's just administratively complicated. So again, another thing to hone in on when we're doing our review.
All right, board policies. I sort of hinted at this at the outset, but you may have policies that are created informally or by accident. Make sure that your policies and your bylaws and articles are consistent. All of these elements create a contract with your members, and they can, to the extent that there are ambiguities, they can result in liability. You have to make sure that when you are drafting policies, for instance, credit policies or other policies of how, animals must be raised, or items like that, you want to make sure that your members are treated equitably. That's a cooperative principle. And so again, you're not discriminating, against certain members, or treating some with more favorably than others. However, it's important to note that equitable may not be equal in all cases. So that's a matter of board discretion and judgment. You want to centralize and write down your policies so that they provide clarity, so that, again, as Levi has said, everybody's on the same page and they understand what the system is. Consider your historical precedents. So, if we're forming a co-op, obviously that's very different than a co-op that's been operating for 100 years, and you may inherit a system that you never would have come up with in the first place when you were forming it, but that's what you have to work with. And so think about, rather than trying to do a complete overhaul of how your co-op has worked, writing down the policy, making it clear, and then trying to maybe implement incremental change as you can, and think about, equity issuance, redemption policies. Those are also very important. I think Levi touched on those a bit, but those are probably going to be your clearest and most important for your contract with your members. Okay. I think this is our conclusion slide then, and we'll hand it over to Steve. But basically, again, periodic review of the legal structure and your co-op documents is a good business practice. It can help you prevent litigation, save you some money. It's part of complying with your fiduciary duties, your duty of care. And also for us lawyers who are geeks, it's just downright fun. It's fun to see kind of the quirks and examine how you've operated and compare it to those governing docs. You should consider establishing a governance committee to help with this. We've seen, sometimes boards will establish a committee that's in charge of the review, and that helps streamline the process rather than going back and forth to the full board. and then engage necessary expertise to assist. Of course, we're always happy to help, but you should also have your accountant on board when you are looking at these documents.
Hey, Sarah and Levi, before we switch over to Steve, I wanted to just address one of the questions that popped up in the chat. There were a couple of comments about this question or issue that you posed, Sarah, about should directors be prohibited from being members of other co-ops. We're not necessarily suggesting that they should, but you should consider the issue, and there are co-ops that do that. And the reason is a director has a fiduciary duty to the co-op that they serve as a director of. And if the question is, can you fulfill your fiduciary duty to co-op A if you're also a member and doing business with co-op B? Now, if it's an ag supply co-op and you're buying, a few dollars worth of fertilizer from another co-op, it probably doesn't alter your loyalties and create conflicts of interest. But if you're the member of a closed cooperative where you're expected to deliver to a particular co-op, or in the case of a dairy co-op where you're primarily delivering to the co-op of the board that you serve on, it could create conflict issues to also be on a member of another co-op. Whose allegiance are you serving, the co-ops or your own personal interest? So that's why that issue comes up, and why co-ops consider that sort of a limitation on who's qualified to serve on the board of directors. In terms of how you monitor it, you ask them. I mean, that's the way that you find out, is there's typically a certification process that a director candidate would sign a piece of paper that says, I'm eligible to serve as a director if elected, and that would include whatever qualifications that they have to satisfy. So hopefully that answered the question. If not, go ahead and add it to the chat, and with that I'll toss it back to Levi and Sarah, or directly to Steve, however you're doing that.
Yes, Steve, why don't you go ahead?
Great. Thanks all for letting me participate. And I thought I'd run through some strategies here for working on collections and dealing with members, and then to a certain extent other customers that aren't paying their bills. Happy to answer any questions, so feel free to ask them in the chat, and I'll try to see them here, or Dan can pop in and I can answer them, or we can talk about them at the end. So really, when you start having a customer or a member that's not paying their bills, the first step is communication. And I think we all have experienced, when we're not having done something, if you're not reminded, or if no one's pestering you, you're probably not going to get to it, because you're going to deal with everybody else that's pestering you. And so one of the first things, and it sounds sort of simple, is just to continue to communicate with any customer or member that's not paying what you're owed. And the other thing to remember too is if they're not paying you, they're probably not paying other people. And so it's important to continue to be at the front of their mind, and also to continue to assert your position and that you are owed money. I really liked what Sarah said at the beginning about getting organized, and I'd echo that. And getting organized when dealing with someone who isn't paying their bill really focuses on reviewing what type of legal claims you would have against them. And what that involves is reviewing any agreements that you have. And so for a member, it'd be taking a look at the membership agreement, the articles and the bylaws, to determine what type of interest you'd be able to have. So Levi mentioned with the equity interests, and I would add that you can also do this with the patronage payments, about having there be offset language that says if the member owes the co-op any money, you can offset that amount against their patronage payments or against their equity. You can also provide a security interest in the co-op, where the co-op holds the security interest in the equity interest and also in the patronage payments, as a further way to protect the co-op if a member isn't paying what it's owed. The other piece to look at for any agreements and to potentially consider adding into any membership agreements would be, things like interest if they aren't paying the bill, And then also things like attorney's fees and other collection costs. Oftentimes we don't see those in membership agreements, but if you're continuing to supply a member, we want to be able to build in at least the possibility of recovering the co-op's costs and trying to collect. And so part of figuring out and starting to work on collecting against a member, it's also probably taking a look at the board policies and trying to think about potential future problems and maybe changing those policies, amending the membership agreement or changing the articles and bylaws to better equip the co-op to be able to recover against a member. Another strategy would be to, especially when dealing with a member, because obviously it's more important and it's a different relationship with a member than it is just with a non-member customer, but that would be to really focus with them on their financials, talk to them about what's going on, figure out if this is something that happened this year, or if this is something that's more of an endemic thing that's going to happen year after year after year. And also just figure out what other creditors are out there and what other things we need to worry about. And so I don't think that you need to go immediately to an aggressive approach or an antagonistic approach. I think you can initially start, especially with members, on a focus of, hey, what's going on? How can we fix this? And try to work with them. And a part of that would be to get an understanding of their financials. And sometimes they don't have a good understanding of their financials either. And so it can be encouraging them to get the right professional help, talk to an accountant or talk to a financial advisor that's going to be able to help them get the right financials so they can understand what's going on with their business as well. Along with getting that financial information is understanding who else is out there that's potentially going to try to collect. And I'd really focus on what other secured creditors are out there. Oftentimes there's sort of one or two major secured creditors. They are going to have security interests in usually all the assets of the member. And that's going to become an issue if we're trying to collect and the secured lender is also trying to collect. But it's important to know who else is out there and who else is maybe not getting paid, because that's going to create sort of a competition for who's going to get paid first. And depending on who the secured creditor is and how much money is out there, sometimes you can have a more cooperative approach where you're both trying to collect and work with the member, or you can have an antagonistic approach and a relationship with the secured creditor where you're fighting over a lot of the same things. There are a couple things that you should immediately talk to legal counsel for, and that's if in the ag space, you get a notice of a farmer-lender mediation. Farmer-lender mediation under Minnesota law requires all collections efforts to stop. And then similarly, if the member files for bankruptcy, there's an automatic stay that gets put in place that also means that all collection efforts must stop. For both of those, if you violate that stay, you can incur penalties and be forced to actually pay the member for any harm that was caused. There's also something called a receivership or an assignment for benefit of creditors, commonly referred to as an ABC. Both of those don't have as specific stay requirements, but they can have that as an element. And so anytime you get a notice that references farmer-lender mediation, receivership, ABC, or bankruptcy, that's a sign to call legal counsel right away. A lot of the other things on this list are things that I think the co-op itself could do as long as it feels comfortable without having to hire a lawyer and start pushing the collection. The final piece is that it's worth considering changing the relationship moving forward. And what I mean by that is if a member is continuing to buy products and needs to buy further products but owes a large balance, you can shift it to a prepay. And I understand this doesn't always work because if the member doesn't have money to pay, the co-op it probably doesn't have money to pay to prepay, but it's worth at least asking, because then that shifts the relationship where there still is an amount owed. And we can talk to the member about how to get that amount paid. But at least on a go-forward basis, the co-op is protected because it's being paid before it's providing any products or services. If we go to the next slide, Levi. So we won't get into the details here because it gets really complicated, but I just want to make sure everybody is aware about what liens are. So liens are the security interests that I mentioned before. And what that means is that there's a priority system that's set up, and the creditor that's holding a perfected lien with the highest priority, they're able to go after the collateral first. And so there's really two main types of liens. One is a consensual lien, generally governed by Article 9, and that would be the normal lien that you see in a mortgage or a security agreement in which the debtor is voluntarily agreeing to grant a lien. There's also statutory liens. Those are set by state statute, obviously, and those established automatically. And so oftentimes there's liens in agricultural space, also in a lot of different types of service space. So like mechanics liens, supplier liens, and different things of that nature. And so it's important to understand, if we're talking about the different creditors and their different interests, who has liens, especially if we think we have a lien, what priority that lien is. You figure out priority by looking at UCC financing statements. And then in the agricultural space, you also have to take a look at the central notice system and check out the statements there to figure out who has priority and who's asserting an interest. Now, when we have competing liens, that's where it's going to be a legal fight, almost certainly. And you'll see that fight in a couple different ways. There's usually a fight about whether or not a lien was properly perfected or who has the proper priority. So who filed that lien first. And then we've also seen more recently a lot of litigation regarding liens versus offsets or set-offs. And that opens a whole can of worms that we don't have time to get into. But just so that you're aware of it, there is a dispute about whether or not a set-off can come first, or if a first position lien comes first. And so that's an issue that likely would get raised, especially with the patronage offset language in the for patronage payments, as well as potentially offset language in the equity interest. I want to just touch quickly on bankruptcy filings, because as I mentioned, a bankruptcy filing creates an automatic stay that can cause severe penalties if that stay is breached. So there's really three major types of bankruptcy that I think a co-op would potentially see. There's a Chapter 7, which is a straight liquidation, a Chapter 11, which is considered a reorganization, and then a Chapter 12, which is an agricultural specific reorganization case. The most important part of the bankruptcy is what I mentioned earlier, and that's the automatic stay. So the automatic stay stops all collection efforts, and if you violate it, you're going to pay a lot of penalties. The other piece that's important to understand is that there's a concept called property of the estate. Once a bankruptcy case is filed, the debtor's interests, all property interests, become property of the estate. And that can include equity interest and interest in patronage payments. But it gets a little more complicated, especially in a Chapter 7 case where there's a trustee instead of actually the debtor that's asserting the interest. And so there can be litigation about when that equity interest or patronage payment actually becomes part of the property of the estate and to what extent. And again, we don't have to get into the details, but I at least wanted to give you a heads up that that's a potential issue, and it's something to talk about with counsel if any of your members were to file for bankruptcy. In a bankruptcy case, there's also a claims process where, if the member is owing the co-op money, the co-op is allowed to file a claim. That's something that you don't necessarily need a lawyer for. It's something that you can just file with the bankruptcy court. But I usually recommend at least consulting with your counsel just to make sure that you're including everything that you need to include to assert a claim. And again, if we have a security interest, that claim has a higher priority in the bankruptcy case. We have more rights. And so it's important to understand what type of claim we have and then how we can assert that claim. The other thing is, if it's a Chapter 11 or a Chapter 12, that means that the member is going to continue to operate moving forward. If they're still seeking products and services from the co-op, there are actually some protections built in with, it's called post-petition services. So services provided after the bankruptcy case is filed. Those get a really high priority of payment, but there's also additional protections that we can build in. So as I mentioned, if any member files for bankruptcy, it's worth talking to counsel immediately, because there's issues with obviously the automatic stay, property of the estate, and then if they're still seeking services from the co-op on a go-forward basis, there's important considerations there in order to protect and ensure that we're at least getting paid for those post-petition services. And finally, it's usually with the bankruptcy filing, but technically in other states, you can have it with an assignment for benefit of creditors or receivership. There's something that's called a preference action. What a preference action looks at is usually it's in the last 90 days, but it can be a look back period of up to a year. Any payments made by the debtor on a debt, and that's a preference. And then you get into whether or not you have a defense. And so the defenses look at whether or not the payment was made in the ordinary course of business. If the debtor always paid you after 30 days of an invoice every month, then that's going to be ordinary course of business. And then another defense is called new value. And the new value defense would be if you provided after you received a payment, you continue to provide services or products. The key part here, though, is that preference liability is something that we incur or run into fairly often. And most of the time it's negotiated a settlement with the trustee. But my goal is always to try to avoid even having to do that. And so a couple strategies on anytime you have a member that is looking like they're in financial trouble and aren't making payments, but are offering to at least pay you something, we can look to structure that payment differently to potentially avoid any preference. So if it's a prepayment, so if they're paying and then you're providing services, that's not a preference. If we structure it as an exchange of value, so that maybe we release a patronage payment in return for getting paid, or we do an offset, those are also structured so that they wouldn't be a preference payment. But again, if you get any preference, usually it'll be a preference demand letter. That's a time to talk to counsel. There's certainly defenses, and so don't be scared. And the other thing I would say is with preference litigation, usually there's a demand letter, there's sometimes a complaint, but these all usually get settled. And so it's not something where you're going to end up in court, most likely. So it's something that you definitely need to be aware of, especially if the member has filed for bankruptcy. And it's something that start figuring out how much preference exposure you have if there's a bankruptcy filing. But it's not something that you need to be worried about being stuck in court for the next 1 to 2 years. It's usually something that we can resolve once we have an understanding of the potential defenses and the potential liability. So I know that was a quick run through. Happy to answer any questions and also any follow-up in the future, but thanks so much for the opportunity to talk to you today. And I'll turn it back over to Dan.
Thanks, Steve, and Sarah and Levi. I guess we'll take a minute or two here to see if anybody has any questions. Feel free to pose them in the chat, or if you want to activate your mic, I think you have the ability to do that as well. So are there questions for anybody? Not seeing anything show up. Give you a minute here. All right, well, if there aren't, I guess what we'll do is, as I indicated earlier, we'll send out some follow-up information so that you have access to some phone numbers and emails here. And if you have questions that come up or that you don't want to ask today, but you want to ask later, please feel free to reach out to us after the fact, and we'll try to answer whatever questions we can. And I guess I'll turn it back to Dan.
Thank you, Dan. Thank you, the entire Fredrikson Byron team, for a very informative presentation. I'm sure that our members have really come across a lot of those questions and comments over these last couple years. So we look forward to continuing to provide this information. And thank you very, very much for being with us today. It's very informative. As our members know, Cooperative Network has a daily presence in the state capitol in St. Paul and the state capitol in Madison. And that work falls to David Larson in Minnesota and Jennifer Wickman here in Madison. They work daily in the state capitol with state agencies, with the governor's staff and legislators across both states, making sure that the voice of cooperatives is heard and that our members are represented. So I wanted to give you a chance today to hear directly from them very briefly on just some of the priorities that they are working on. And we'll start with David in St. Paul. Thank you, David.
Thanks, Dan, and thanks for this opportunity today to speak to each of you that have attended this webinar. To introduce myself, David Larson, Cooperative Network, been with the organization and with you all since 2019. Before I get into what we're working on for this upcoming session, I want to briefly touch on what we worked on this past session to touch on the successes. So Every single item that we met with legislators about during our lobby day in 2021 was completed, whether it was $70 million for broadband easement language that we've been searching for a few years, $795 million for transportation, a lot of that being in rural areas, and tax conformity for PPP loans. All of these top line items that we advocated for throughout the session were completed, and it has a lot to do with each and every one of you and Cooperative Network's reach, whether it be in the ag community, whether it be in the energy community. Our broad reach really helped accomplish this, getting to each member, whether it be the governor or legislator. To go over our process a bit, we start with the resolution process, which starts with you. We started that process a few months ago and have developed kind of an outline of what we're working on moving towards this session. But that process, of course, isn't done. So any issues that you all have, please feel free to come to Jennifer and I, and we'll work on those towards this next upcoming session. To focus on a few issues that we're working on this session, first I'll start with Hero Pay. This is bonuses for those of you who did not have an opportunity to work from home throughout the pandemic. Next, we'll go to drought assistance. This is help for farmers, excuse me, to acquire irrigation for water infrastructure via state funding. Next is workforce development. This is helping to find new labor for those who are trying to increase their workforce. Next, please reach out to us if you have any other issues that you will be working on throughout the session. Please let us know. Thank you.
Thank you, David. Now we'll turn to Jennifer Wickman, whose work in Madison and Wisconsin mirrors David's in Minnesota. Jennifer.
Hi, thank you. Thanks, everybody. Like David said, we had some great successes with our budget last session. The top item issue I'd like to mention is that we were able to secure $400,000 for feasibility studies for cooperatives, and we should be able to be announcing that application pretty soon. I'm really looking forward to be able to put that on our website and be able to tell you that if you know of a cooperative that is interested in forming, or people who are interested in forming cooperative, they will be able to go to the Wisconsin Economic Development Cooperative. That's a public-private entity within the state of Wisconsin, and get grants to form their cooperative. So that was something we're really excited to be able to work on. But like in Minnesota, the Wisconsin legislature is in session right now. Tons of bills are being worked through, and the top priorities we're working right now are personal property tax. We're working with the credit unions on a credit union bill and a bunch of ag bills. But I'll talk about them really quickly. The personal property tax bill, we worked on that during the budget last session. There was a great bill that we've been working on over time. In essence, we want to repeal the personal property tax. It's been chipped away over time, and we've been a part of that every bit. There was enough money in surplus that we really thought we had a chance to get rid of it this time with the bill that was part of the budget. But Governor Evers vetoed it, kept the money, but vetoed it because he said there was enough concern with two things. One, the railroads thought that it could be could set up a constitutional problem with how they're taxed. And of course, locals are just very concerned. That's how they get their money, and they're very concerned that they won't get enough money. So Evers vetoed it, but kept the money in the budget to say, I want to come back, because he does want to work on this. He did just now come back with leading Democrats with a bill and said, okay, I'm ready to work on this. Here's my suggestion. And he offered a bill. So we're going to work with him on that bill. Unfortunately, I don't have a lot of hope for it, even though we're going to work with it because of politics, because the Republicans who are in the majority aren't likely to want to work with the bill that he's introduced. And it also has a CPI, a consumer price index, which means it increases over time, how much money it gives to local governments. So that's a poison pill for the Republicans. They're not gonna want to just have this increase over time for local governments. So that's sort of dead in the water right now. We will continue to work on that bill and hopefully it passes, but I don't see it really happening in this legislature. The credit unions have introduced a bill that we're going to work with them. This is sort of just a housekeeping. It's time for them to update all their rules. Things like letting them put ATMs off-site without always having to go to the Office of Commissioner of Credit Unions and tell them about it. Unfortunately, the Banking Association has come out in opposition, mostly because of in opposition to the tax status of credit unions. So we'll work with the credit unions and hopefully get this done with them. But I see it sort of as a uphill battle at this time until maybe things are changed so that the bankers are more comfortable with it. And then there's a series of ag bills that we're really going to work on. A lot of ag bills were passed in the assembly last session just before the pandemic hit and closed everything. So we're going to try and get those done now. Things like cover crop insurance, cover crop insurance for premium rebates, increased well compensation, especially when wells are contaminated with nitrates, more funding for producer-led watershed protection groups, county conservation department grants, and a hydrologist position within the UW. Finally, fair labeling bills. For example, only milk that comes from animals could be actually labeled as milk. So there's 3 of those bills that we're in strong support of, working with the other ag groups. We really hope those will be passed, but there are 6 Southeastern senators who are strongly opposed to those. And we do not know why, and they're really holding strong on those. So all the ag groups are working really hard, but those 6 senators, 6 Republican senators are really holding strong on those. So that's our roadblock right now. So that's the update. And just as David said, we welcome your questions and we welcome your help on all of these issues.
Thank you, Jennifer.
You're welcome.
As you can see, with the governance issues that Fredrikson and Byron's team reviewed, and all the work that's going on in both state capitals, there's a lot going on, and we really need communication from our members of the things that are of concern to you so that we can take them to the legislators and the governors in both states. Also on the federal level, there's been a lot of discussion on COVID mandates, discussion on the distribution of stimulus money throughout the states. These are things that we work on behalf of our members on every day. We need your input. As David said, we have a very extensive resolution process at Cooperative Network that really drives our positions, and that really comes from the ground up with our members. Remember that Cooperative Network is a cooperative of cooperatives, and our power really comes from our cooperative voice and all being together in the cooperative community. I wondered if we should just take one look, Dawn and Kristen, if you could, to see if there are any questions that we need to address in the chat. Or if anyone has any questions, please feel free to unmute and speak up now while we still have the team together. Not hearing anything, Kristen?
Nope, I was just going to say it looks like we've addressed everything. And like Dan said in the chat, we will provide the PowerPoint deck as well as this recording that'll be available afterwards for any follow-up.
Okay, thank you. I didn't want to leave any questions unanswered. Give everybody time to think about everything that we covered today. Please be in contact at any time with me and my team here at Cooperative Network. It's a real honor to work with all of you. It's been an honor today to have Fredrikson and Byron's experts with us to discuss all of this. So thank you for joining us. Please put on your calendars Cooperative Network's annual meeting. It will be virtual this year, and it's at 1 p.m. on November 16th. So all of our members will be getting or already have the information on the annual meeting. And then make sure you stay in touch and watch our website and your email box for future webinars and events, as we all hope to return to in-person events in the new year. Thank you for being with us, everyone. Thank you again to Fredrikson and Byron for joining us today. Stay well. Have a good day.